Case 1. Gwendolyn Graham and Catherine Wood. 5 elderly women were residents of Alpine Manor Nursing Home in Walker, a suburb of Grand Rapids. Their names are part of the public record, established in court proceedings and documented in news coverage of the trial. Mason was 79 years old, Edith Cook was 98, Marguerite Chambers was 60, Myrtle Luce was 95, Belle Burkhart was 74. Each had been living with significant cognitive or physical decline. Each died in the early months of 1987. None of the deaths was treated as suspicious at the time. All 5 were recorded as natural deaths. No autopsies were performed. That is the fact that defines Case 1. For more than a year after those 5 deaths, there was no investigation, because there was no recognized reason to open one. The deaths of elderly, medically fragile residents in a long-term care facility produced no clinical alert, no institutional review, and no contact with law enforcement. What changed that was not a forensic discovery. It was not a pattern flagged by a pharmacist or an auditor. It was a personal disclosure made by one of the 2 individuals at the center of this case. Gwendolyn Graham was born in 1963. She relocated to Michigan from Texas in 1986 and took work as a nurse's aide at Alpine Manor. Catherine May Wood was born in 1962. She had grown up in Michigan and worked at the same facility, where she held a supervisory position over Graham. The 2 became personally involved in 1986. It is important to be precise about their roles from the start. Graham and Wood were nurses' aides, direct care staff, rather than licensed registered nurses. They administered basic care, assisted with daily activities, and worked the floor under the supervision of licensed nursing staff. This case is included in this documentary record because it is the most consequential nursing personnel homicide prosecution in Michigan history, because it fundamentally reshaped how families, regulators, and the public viewed the safety of nursing home residents, and because it introduced questions about evidence standards, plea agreements, and identity that remain unresolved today. The relationship between Graham and Wood ended when Graham became involved with another person and relocated back to Texas, where she obtained work in a hospital setting. Sometime in 1988, Wood disclosed details of the deaths at Alpine Manor to her former husband, Kenneth Wood. After a period during which he considered what to do with the information, Kenneth Wood contacted law enforcement. That disclosure, not physical evidence, not a clinical flag, not an institutional audit, is what opened this investigation. The investigation was conducted by detectives from the Walker Police Department. In forensic terms, it was an extraordinarily difficult case from the outset. The deaths had been recorded as natural. More than a year had passed. Investigators exhumed and examined the remains of 2 of the 5 named victims, but those examinations did not produce direct physical evidence linking the deaths to any person. This left investigators building a case almost entirely on statement evidence and corroborating witness accounts. Detectives conducted extended interviews with Catherine Wood, who incrementally described what she said had occurred and her own role during those events. Investigators then sought corroboration from other Alpine Manor staff members, who described workplace conversations and conduct they had previously not considered significant. The investigation also extended to Texas, where individuals who had become acquainted with Graham after she left Michigan were interviewed. The reliance on statement evidence became the defining legal controversy of this case, a controversy that has not been resolved to everyone's satisfaction in the decades since the trial. Graham and Wood were both arrested in December 1988. Wood entered a plea agreement. She pleaded guilty to 1 count of second-degree murder and 1 count of conspiracy to commit second-degree murder, and in exchange, she agreed to testify against Graham at trial. Graham was charged with 5 counts of first-degree murder and 1 count of conspiracy to commit murder. Graham's trial took place in Kent County in 1989. Wood was the prosecution's primary witness. She testified that she acted as a lookout while Graham caused the deaths of the 5 residents, and she described the context of the conduct. A second witness, a woman Graham had become involved with after returning to Texas, testified that Graham had described the killings to her during their time together. The defense challenged the reliability of both witnesses directly and repeatedly. With no physical evidence and a central witness who had negotiated a reduced charge in exchange for testimony, defense counsel argued that the accounts were not credible and that Wood had substantial personal incentives to shift responsibility onto Graham. Journalists and legal analysts who covered the trial also noted that the proceedings included repeated references to Graham's identity in ways that, at minimum, reflected the social climate of the late 1980s, and that those references would resurface as a significant point of contention in later review of the case. The jury returned its verdict on November 3, 1989. Graham was found guilty on 5 counts of murder and 1 count of conspiracy to commit murder. The court imposed 5 consecutive life sentences, with no possibility of parole. Catherine Wood was sentenced under her plea agreement to a term of 20 to 40 years. In January 2020, she was released from prison on good behavior and relocated out of state. Graham has remained incarcerated and continues to serve the 5 life terms at the Women's Huron Valley Correctional Complex in Ypsilanti, Michigan. The civil litigation that followed centered on the owners and operators of Alpine Manor, with families of the victims raising claims related to the facility's hiring and supervision practices. The facility ceased operating under its original ownership and was succeeded by a different operation at the same location. The case became the subject of extensive coverage in books, documentary productions, and broadcast journalism over the years that followed. The case also produced a sustained legal controversy that has not been closed. Decades after the verdict, the Michigan Innocence Clinic filed a formal clemency petition on Graham's behalf. Graham, now in his 60s and living as a transgender man, has consistently maintained that no murders occurred and that what became the prosecution's central evidence originated as dark workplace conversation that Wood later characterized as something it was not. Walker police have acknowledged the absence of physical evidence while maintaining that the conviction was sound. Both positions are part of the record. Case 1 stands as the foundational example in Michigan of a homicide prosecution constructed without physical evidence, built on cooperating witness testimony and corroborating accounts, and subject to ongoing legal challenge based on those very characteristics. It is also the reason that nursing home oversight, hiring background checks, and the treatment of unexplained deaths among vulnerable populations became subjects of sustained legislative and regulatory attention in Michigan and nationally in the years that followed the trial. Case 2, Judith Sobel. A 3-year-old child, Ophelia, Missouri, was dependent on a ventilator and required overnight in-home nursing care. A registered nurse named Judith Maria Sobel was assigned to provide that care on the night of June 19th into June 20th, 2022. By the early morning hours of June 20th, the child was unresponsive and had ceased breathing. The child died. When law enforcement arrived at the family's home in Coloma Township, they found Sobel on the floor of the residence, incoherent. She later told officers that she had taken methamphetamine before reporting for her shift. Officers recovered 2 methamphetamine pipes and a small container of crystal methamphetamine from her purse. The child was 3 years old. The child died. We will state those facts, as the record requires, and we will focus from this point on the investigation, the proceedings, and the outcome. Judith Maria Sobel was a registered nurse, formerly of South Haven, Michigan. Her professional assignment was overnight in-home nursing care for medically complex pediatric patients, a role that places a licensed professional in a home setting, without the on-site oversight of a hospital floor or care facility, responsible for the monitoring and maintenance of life-sustaining equipment. According to trial testimony, Sobel arrived late for her shift on June 19th. In the early morning hours of June 20th, the child's mother, Shelby, Missouri, was awakened by alarms from the medical equipment in the child's room. She found the child unresponsive and found Sobel unresponsive to her. The child's father, James, Missouri, attempted resuscitation while emergency services were summoned. Those efforts did not restore the child. Medical personnel who arrived were unable to revive the child. The child was later pronounced dead. Officers from the Coloma Township Police Department responded to the scene. They found Sobel on the living room floor of the home. In the course of their investigation at the scene, officers located the methamphetamine pipes and controlled substance in Sobel's bag. Sobel subsequently told officers that she had used methamphetamine earlier that day before reporting for the shift. The investigation combined the scene evidence, the physical items recovered, the state of the medical equipment, and the positions of the individuals found, with Sobel's direct admission to law enforcement. The tracheal tube connecting the child to the ventilator had been disconnected. The medical equipment and its components were documented at the scene as part of the evidentiary record. Sobel's admission established that she had been under the influence of a controlled substance while responsible for the child's care and for the monitoring of that life-sustaining equipment. Sobel was charged in Berrien County with second-degree murder and with possession of a controlled substance, specifically methamphetamine. Her bond was set at $500,000. In November 2022, before the criminal case reached its conclusion, the Michigan Department of Licensing and Regulatory Affairs issued a summary suspension of Sobel's registered nursing license. The suspension was based on an administrative complaint filed on behalf of the department by the Office of the Attorney General, and it reflected the regulatory finding that allowing Sobel to continue practicing during the pendency of the criminal case would pose an immediate risk to patient safety. The criminal trial took place over 3 days in Berrien County Circuit Court before Judge Angela Pasula. The prosecution presented testimony from Shelby, Missouri, who described waking to the equipment alarms and finding her child not breathing and Sobel incoherent. James Missouri testified regarding his attempt to resuscitate the child while waiting for emergency services. Law enforcement officers testified to finding Sobel at the scene and to her subsequent statements regarding methamphetamine use. The physical evidence recovered from Sobel's bag was introduced and authenticated. On February 23, 2023, the Berrien County jury returned a verdict of guilty on the second-degree murder charge. The jury also found Sobel guilty on the methamphetamine possession charge. Berrien County Assistant Prosecutor Taylor Koch stated following the verdict that while the prosecution was satisfied with the outcome, the loss of a child remains central to the case, regardless of the verdict. Sentencing took place in May 2023. The court imposed a term of 30 to 75 years in prison on the murder conviction. Sobel was remanded to serve that term at the Women's Huron Valley Correctional Facility. The licensing proceedings that followed the criminal conviction illustrate the two-track structure of accountability in Michigan healthcare cases. In February 2023, concurrent with the criminal verdict, the Michigan Board of Nursing Disciplinary Subcommittee revoked Sobel's nursing license and imposed a fine of $150,000. Under the initial terms of that administrative order, Sobel retained a theoretical eligibility to petition for reinstatement after 3 years upon payment of the fine. The criminal conviction, however, constituted a separate and independent violation of Michigan's Public Health Code, one that carried its own basis for permanent revocation. The Attorney General's Office, acting on behalf of the Department of Licensing and Regulatory Affairs, filed a second administrative complaint grounded in the conviction itself. On November 21, 2023, the Board of Nursing Disciplinary Subcommittee voted to permanently revoke Sobel's registered nursing license, eliminating any future pathway to reinstatement. Attorney General Dana Nessel stated that in addition to the 30 to 75-year prison sentence, Sobel would never practice healthcare again. The Sobel case is instructive on several levels beyond the criminal verdict. The two-track accountability structure, criminal prosecution running parallel to, and then reinforcing, professional discipline, is the design Michigan has built for cases of this kind. A conviction under the criminal standard does not automatically produce a licensing outcome. That requires a separate proceeding under the Public Health Code. And a licensing revocation that leaves open a reinstatement pathway is qualitatively different from a permanent bar. The second administrative action in this case closed that gap. The case also highlights a structural vulnerability in home health care, the absence of institutional oversight at the point of care. In a hospital or residential care facility, colleagues and supervisors are present. In a private home on an overnight shift, the nurse is the only professional in the building. That structural difference is relevant both to the risk the conduct posed and to the detection timeline. It was the family's own presence, their responsiveness to equipment alarms, and their ability to summon help that limited the response gap in this case. Case 3. Esther Nadger. A family kept vigil at the bedside of their terminally ill daughter at the University of Michigan Medical Center. While they were present, they observed a nurse draw from the patient's intravenous morphine line. They reported what they saw. That report, direct eyewitness observation by family members at a bedside, opened a criminal investigation that ended in a conviction. Esther Rebecca Nadger was a registered nurse with nearly 20 years of experience at the University of Michigan Medical Center in Ann Arbor. Trial testimony established that she had a documented history of substance dependency. 2 days before the events central to this case, her supervisor, Christopher Title, testified that he had found her in a severely disoriented state while on duty. She believed she was at home rather than at a patient's bedside, and she was physically unsteady. Title walked her to the emergency department for evaluation. She returned to work approximately 6 weeks later. The patient was Lucretia Dobbins, a 26-year-old woman who had lived with severe disabilities since infancy, following a case of spinal meningitis, contracted when she was 3 months old. Over the course of her life, she had lost her sight, experienced seizures, and was unable to walk or speak independently. In August 2008, shortly after her 26th birthday, she contracted pneumonia and was admitted to the University of Michigan Medical Center. Her family placed her on comfort care, the clinical term for care designed to maintain the comfort of a patient who is not expected to recover. Lucretia Dobbins died in September 2008. The case was not discovered by a hospital audit. It was not flagged by an automated dispensing system. It was not detected by a pharmacy review. It was observed directly by members of the Dobbins family, who were present at the bedside on the day their daughter and sister died. They saw a nurse draw from the patient's morphine intravenous line and reported it to the hospital. That report triggered an institutional review. Najer's supervisor testified that a review of medications administered to patients under Najer's care over the previous 6 months initially found no documented discrepancy. However, on the specific day of Lucretia Dobbins' death, a 100 cubic centimeter intravenous bag of morphine that had been pulled from the pharmacy for another patient under Najer's care in the critical care unit went missing and was never subsequently accounted for. The investigation also incorporated the results of a prior clinical evaluation in which Najer had tested positive for opiates and had acknowledged ongoing use of opioid-based medications. The charges brought against Najer were framed as larceny in a building, a property theft charge, rather than a charge related to patient harm. The prosecutorial theory reflected a specific clinical characteristic of intravenous morphine administration. When morphine is delivered via a pump at a set rate, a patient receives a continuous, controlled dose. The medication in the IV bag is replenished by the pharmacy as it depletes. If a nurse removes morphine from the bag itself, rather than intercepting it at the pump continues to deliver whatever volume of fluid remains, but the analgesic content of that fluid is reduced or absent. This meant the charge was structured around the theft of a controlled substance rather than the direct denial of medication from an individual dose. Najer was charged with 4 counts of larceny in a building in Washtenaw County. The defense mounted a detailed records-based challenge. Najer's attorneys, Deborah Keene and Robin Stevens, argued that no controlled substance was actually missing and that the apparent shortfall in the accounting was attributable to arithmetic errors and documentation discrepancies within the hospital's recording systems. Defense counsel stated in court that there could be no larceny if nothing was missing. The defense called a veteran University of Michigan nurse who testified to discrepancies between handwritten nursing reports and the computerized dispensing records. The prosecution responded by presenting evidence that the defense's analysis had failed to account for overfill, the practice of including a volume of excess fluid in intravenous bags above the labeled amount, meaning that calculations based solely on labeled volumes would consistently show apparent shortfalls that did not reflect actual missing substance. Najer elected to waive her right to a jury trial. The case was heard before Washtenaw County Circuit Judge David Swartz. The prosecution called 9 witnesses in total, including multiple members of the Dobbins family, who testified to observing Najer draw from the patient's IV line. On November 13, 2009, immediately following the conclusion of closing arguments, Judge Swartz convicted Najer on 3 of the 4 counts of larceny in a building and acquitted her on the 4th count. Each conviction count carried a maximum sentence of 4 years. Sentencing was scheduled for January 7, 2010. Najer remained free on bond during the interval between conviction and sentencing. The publicly available record from the local reporting outlet that covered the trial in full documents the conviction clearly but does not include reporting on the sentence ultimately imposed. We therefore confirm the conviction as established and note that the specific sentence of record is not available in the public sources reviewed for this production. The Najer case is significant for what it demonstrates about the limits and capabilities of institutional detection systems. The conduct was not identified by the hospital's routine 6-month controlled substance audit, which initially produced no finding of discrepancy. It was identified by family members at a bedside who were paying attention, who recognized what they saw, and who reported it. The forensic corroboration, the missing morphine bag, came afterward, as an evidentiary confirmation of the observation, rather than as an independent detection. The prosecutorial choice to charge larceny rather than a patient harm offense reflects the clinical mechanics of how morphine is administered via intravenous pump and illustrates the importance of how investigators and prosecutors frame the conduct they are charging in diversion cases. The broader institutional lesson from this case is one that recurs throughout this episode. Controlled substance accounting systems are forensic tools, and gaps in them create and sustain the opportunity for diversion. When those systems fail to detect diversion in 6 months of routine review, the detection falls to whoever is physically present and paying attention. We are 3 cases in, with 7 more to go. If this documentary record is useful to you, if the structure, the sourcing, and the factual approach are what brought you here, take a moment right now to hit the like button and subscribe to Hidden Case Diaries. Turn on your notifications so you do not miss the next case file. Every subscription and every like is what allows this channel to keep producing this kind of carefully sourced, court-based documentary work. If you have a question about the forensic methods in any of these cases, a point of law you want to understand better, or a suggestion for a future case file, put it in the comments. We read them, and they shape what we produce next. Thank you. Back to the record. Case 4. Allison Marshall. A nurse in a hospital interventional radiology unit removed fentanyl from medication vials, replaced the fentanyl with saline solution, glued the caps back onto the vials, and returned them to the automated dispensing machines on her unit. Those vials were then drawn and administered to patients who were entitled to receive a powerful analgesic and, in some instances, received only saline. The tampering was discovered when a nurse administered a dose from an affected vial, and the patient showed no clinical response at all. A medication with an unmistakable physiological effect produced none. Allison Renee Marshall was 46 years old at the time of the charges. She was a registered nurse working in the interventional radiology unit of Bronson Methodist Hospital in Kalamazoo, Michigan. Interventional radiology is a specialty that uses imaging guidance to perform minimally invasive procedures. Many of those procedures require sedation and pain control. The unit accordingly maintained a supply of fentanyl, a synthetic opioid that is, by established pharmacological measurement, approximately 100 times more potent than morphine by weight, in its automated medication dispensing machines. The conduct for which Marshall was charged occurred in July and August of 2020. According to the federal indictment, Marshall used syringes to extract fentanyl from vials, replaced the drug with saline solution, and returned the compromised vials to the dispensing machine inventory. Records from the Michigan Department of Licensing and Regulatory Affairs, cited in the administrative proceedings that followed, identified the replacement substance as saline. Hospital transaction records showed that Marshall had checked out doses of fentanyl for patients 14 times during July and August 2020, subsequently canceled those transactions, and returned the product to inventory, a pattern inconsistent with normal clinical dispensing practice and consistent with diversion. The discovery of the tampering followed a clinical anomaly. A nurse administered what the vial's label indicated was fentanyl to a patient, and the patient did not respond as fentanyl patients consistently respond. The absence of the expected clinical effect raised immediate concern. The nurse reported the anomaly, and the matter was escalated to the hospital pharmacy. A staff pharmacist conducted an examination of the unit's dispensing machine inventory. The pharmacist found that several fentanyl vials had caps that appeared to have been reattached with adhesive, an observation inconsistent with the sealed, factory-intact caps that medication vials should display when properly dispensed. The hospital referred the matter to the United States Food and Drug Administration's Office of Criminal Investigations. FDA forensic laboratory examination of the vials with reattached caps found needle puncture marks consistent with the use of a syringe to extract the original contents and replace them with another substance. Quantitative laboratory analysis of the remaining contents of the affected vials established that they contained 3% or less of the fentanyl specified on the label. The vials had been almost entirely depleted of their labeled active ingredient and filled with saline. On August 24, 2020, Marshall met with hospital representatives and gave a direct admission. She acknowledged removing fentanyl from vials in the dispensing machines, extracting the drug using syringes, replacing it with saline, reattaching the caps with adhesive, and returning the vials to inventory. She acknowledged doing so on multiple occasions, and she stated that the purpose of the diversion was her own personal use of the drug. Bronson Methodist Hospital terminated her employment. Michigan's Department of Licensing and Regulatory Affairs suspended her nursing license in October 2020. A federal grand jury in the Western District of Michigan returned an indictment charging Marshall with tampering with a consumer product. Under the federal product tampering statute, this offense carries a maximum penalty of 10 years in federal prison. The statute is designed to address the deliberate contamination or adulteration of products intended for distribution and consumption, and its application to pharmaceutical tampering by healthcare workers reflects the federal government's position that medication vials in a hospital supply chain fall within its scope. Marshall pleaded guilty before United States District Judge Hala Y. Jarboe in May 2022. United States Attorney Mark Totten, in announcing the guilty plea, stated that patients entering a hospital must have confidence that they will receive the treatment they are promised. A representative of the FDA's Office of Criminal Investigations stated that those who knowingly tamper with medicines place patients' health at risk. The court imposed sentence on September 21, 2022. Marshall received 5 years of probation and a fine of $5,000. The court also confirmed the forfeiture of her nursing license. Reporting on the sentencing noted that the sentence fell below the advisory range under federal sentencing guidelines, and that mitigating factors cited by the court included Marshall's entry into substance use treatment following her arrest and the absence of any further misconduct during the period between her termination and sentencing. The Marshall case established the evidentiary template that federal prosecutors in Michigan would apply in subsequent nurse tampering prosecutions. The combination of pharmacist observation, dispensing machine transaction records, FDA laboratory analysis, and admission produced a coherent, reproducible investigative framework. The case also became a reference point for institutional discussion about hardening automated dispensing machines, the tamper-resistant design of caps, the addition of tamper evidence indicators, and the protocols for verifying vial integrity before dispensing at hospitals nationally. Case 5. Travis Eskridge. A registered nurse in a Detroit hospital emergency department removed fentanyl from medication vials 178 times over the course of approximately 3 months, replaced the drug with another substance, and returned the tampered vials to the locked drug storage system in the emergency room, knowing those vials would be administered to patients who were presenting with acute pain and injury. He was indicted, pleaded guilty, and was sentenced to 2 years in federal prison. Travis Eskridge was 53 years old at the time of the indictment and 54 at sentencing. He had worked as a registered nurse in the emergency department at Ascension St. John Hospital in Detroit, in Grosse Pointe Park, Michigan. Emergency departments, by their nature, treat patients who are often in significant acute distress, trauma, injury, acute illness, or medical crisis, and many of those patients require pain management during their evaluation and treatment. The emergency department maintained a supply of fentanyl in a locked drug storage system to meet those clinical needs. The conduct occurred over a period from May 1st through August 9th, 2022, a span of approximately 3 months and 8 days. According to the federal indictment, Eskridge removed fentanyl from vials without authorization during that period, replaced the drug with another liquid, and returned the tampered vials to the locked storage system. He also admitted, as part of his guilty plea, to a broader pattern of fentanyl theft over a 9-month period and to obtaining fentanyl by fraud for his personal use. The indictment identified 178 unauthorized removals within the charged 3-month window. The tampering and thefts were discovered in August 2022 when internal hospital controls detected the discrepancies. Ascension St. John removed Eskridge from his position at that time. The hospital then referred the matter to federal investigators. The case was taken up by special agents of the Food and Drug Administration's Office of Criminal Investigations, the same federal unit that had investigated the Bronson Methodist Hospital case in the Western District of Michigan. The forensic and records work in the Eskridge investigation followed the same established framework. Agents reconciled the transaction logs of the locked drug storage system, a detailed digital record of every withdrawal, cancellation, and return made from the system, and identified the full pattern of unauthorized removals within the charged period. The 178 figure cited in the indictment was established through that transactional record, not through sampling or inference. Analysis of the tampered vials confirmed the presence of a substitute substance in place of the labeled fentanyl. The indictment in the Eastern District of Michigan was unsealed in early 2025. Eskridge was charged with 3 counts of tampering with a consumer product, specifically the Schedule II controlled substance fentanyl, with each count carrying a maximum of 10 years in federal prison. He was additionally charged with 1 count of theft of medical products by an employee, carrying a maximum of 5 years, and 1 count of obtaining a controlled substance by fraud, carrying a maximum of 4 years. Following his indictment, Eskridge was released on bond with a specific condition attached. He was prohibited from seeking or accepting any employment as a nurse. Eskridge pleaded guilty on May 7, 2025, before United States District Judge Susan K. DeClercq in the Eastern District of Michigan. In his plea, he admitted that he tampered with vials of fentanyl that he knew were intended to be administered to emergency room patients. United States Attorney Jerome F. Gorgon, Jr., in a statement following the plea, said that when Eskridge placed tampered vials back into the hospital's medical supply, he exposed patients in need of pain relief to continued suffering. A representative of the FDA's Office of Criminal Investigations stated that emergency room patients are entitled to trust that the pain relief medications ordered by their physicians will actually be administered to them. The court sentenced Eskridge on November 26, 2025. Judge DeClercq imposed a term of 2 years in federal prison. Placed alongside Case 4, the Eskridge prosecution demonstrates the consistency and transferability of the federal approach to nurse tampering in Michigan. The same federal statute, tampering with a consumer product, was applied in the Eastern District as in the Western District. The same federal investigating agency, the FDA's Office of Criminal Investigations, built the evidentiary case. The same core framework, transactional records from locked storage systems, laboratory confirmation of the substitute substance, and admission produced the charge and the conviction. The geographic range, from Kalamazoo to Detroit, confirms that this investigative approach is not limited to a single jurisdiction or a single hospital system. It is a portable, replicable framework for detecting and prosecuting pharmaceutical diversion through tampering. The Eskridge case also reinforces the institutional point about who the patients are in these cases. Emergency department patients prescribed fentanyl are by definition in acute need of pain management. The clinical promise of that medication and the harm of its absence is not abstract. Federal prosecutors in this case, as in the Marshall case, chose to frame the harm not as a personal drug offense, but as a breach of the duty owed directly to patients. That framing, and the 2-year federal sentence that followed, is part of the record. Case 6. Beverly Ann Bratcher. A licensed practical nurse working at a state facility for veterans became aware that a resident had been given 2 incorrect medication doses. As a licensed nurse, she was legally required to report that error to a supervisor or a physician. According to the Michigan Department of Attorney General, she did not. She was charged with second-degree vulnerable adult abuse, a 4-year felony, in September 2022. Beverly Ann Bratcher was 56 years old at the time of the charge. She held a license as a licensed practical nurse and was employed at the Grand Rapids Home for Veterans, a state-operated residential facility that provides care to veteran residents. The resident population of that facility is classified under Michigan law as vulnerable adults, a legal designation that activates specific statutory protections, and, where those protections are violated through abuse or neglect, specific criminal penalties. The events at the center of this case occurred in December 2020. The record, as publicly available, is specific about the nature of the alleged offense. 2 incorrect medication doses were administered to a resident of the facility. The identity of the person or persons who administered the incorrect doses is not identified in the public charging record. What the state charged is what allegedly came next, or, more precisely, what allegedly did not come next. A licensed nurse who becomes aware that a patient has received an incorrect medication dose has a defined professional obligation to report that error to a supervisor or a physician in a timely manner. That obligation is not simply a matter of institutional policy. It is embedded in the legal and professional framework governing nursing practice in Michigan. The report of a medication error is itself a safety mechanism. It notifies a physician who can assess the clinical impact of the error and intervene if necessary. It creates a record that other caregivers can see. It triggers a review process designed to identify what went wrong and prevent recurrence. When that report is not made, all of those safety mechanisms fail to activate. The allegation against Bratcher is that she became aware of the incorrect doses and failed to make the required report. The Michigan Department of Attorney General's Healthcare Fraud Division, which functions as the federally certified Medicaid fraud control unit for the state of Michigan, developed the case through its oversight function. The division investigates patient abuse and neglect allegations at care facilities that serve Medicaid-eligible populations, and this case came to the division through that investigative channel rather than through a contemporaneous report made at the bedside. The investigation was documentary in nature. Investigators reviewed the facility's medication administration records, the detailed log of what was given to each resident, when it was given, and by whom, and compared that record against the prescriptions and the facility's documented reporting chain. The absence of a timely incident report, cross-referenced against the medication administration record, formed the evidentiary basis of the charge. The charge was filed in the 61st District Court in Kent County. Per the Michigan Attorney General's press release of September 1, 2022, Bratcher was charged with one count of second-degree vulnerable adult abuse, which carries a maximum penalty of 4 years in prison. Attorney General Dana Nessel stated that caring for vulnerable adults is a significant responsibility, requiring special care, and that failure to fulfill that responsibility can have dire and even criminal consequences. Bratcher was scheduled for video arraignment on September 14, 2022. At this point, the public record stops. We conducted a review of available public sources and were unable to locate any reporting or documentation of a plea, a trial verdict, a dismissal, or a sentence in the Bratcher case beyond the September 2022 charging and arraignment. This is not unusual for district court healthcare cases that do not produce a high-profile trial or sentencing proceeding, and the absence of subsequent public reporting does not, by itself, indicate a resolution of any particular kind. We state plainly that the final disposition of the Bratcher case is not established in the public record sources reviewed for this production. The charge is an allegation. Bratcher is presumed innocent unless and until proven guilty. What the charging record does establish, regardless of outcome, is the legal and institutional principle that the obligation to report a known medication error is itself a mandatory safety function, and that Michigan treats the willful failure to fulfill that obligation at a care facility serving vulnerable adults as a basis for criminal liability. The conduct alleged in the Bratcher case is not the medication error itself. That was made by someone else. The alleged offense is the failure to report it. That distinction is central to how Michigan and other jurisdictions have begun to approach oversight at residential care facilities. The error itself, however serious, could potentially be addressed clinically if a physician is notified promptly. The failure to report it removes that clinical opportunity. It also removes the institutional opportunity to investigate and correct the underlying process that led to the error in the first place. Michigan's decision to frame that failure as a potential form of vulnerable adult abuse reflects the regulatory judgment that silence, in this specific professional context, is not a neutral act. Case 7. Patricia Lynn Nash. A patient at a nursing home in Taylor, Michigan, suffered a fall. The patient subsequently died. When the Michigan Department of Licensing and Regulatory Affairs conducted an on-site regulatory investigation and requested the patient's medical records, the allegation is that 2 of those records, neurological assessments documenting the patient's condition after the fall, had been falsified. Patricia Lynn Nash, a registered nurse employed at the facility, was charged with 2 felony counts of intentionally placing false information on a medical chart. Patricia Lynn Nash was 41 years old at the time of the charge. She was employed as a registered nurse at a nursing home located in Taylor, Michigan, within Wayne County. The facility is not identified by name in the available public record at the charging stage. The sequence of events that produced this case began with a patient fall. Falls in nursing homes are serious adverse events. They are the subject of specific regulatory scrutiny, required documentation protocols, and clinical follow-up requirements. When an elderly or disabled patient falls and strikes the floor or a surface, the standard of care requires documented neurological monitoring to detect any delayed manifestation of injury, including changes in neurological status that may not be apparent immediately at the time of the fall. That documentation, the neurological assessment, is both a clinical tool and a regulatory record. After the patient's fall and the patient's subsequent death, the Michigan Department of Licensing and Regulatory Affairs opened an investigation. During a regulatory site visit to the facility, investigators requested the patient's medical records, specifically including the neurological assessments that should have documented the patient's post-fall monitoring. The allegation in the charging document is that 2 of those assessments had been intentionally falsified. That is, that information had been placed in the records that did not reflect care actually provided. The forensic methodology in a records falsification case is documentary. Investigators compare the contents of the challenged records against other available evidence of what actually occurred during the period in question. That comparison draws on multiple sources: staffing records showing who was on duty and when, other entries in the medical record made by different staff members during the same period, equipment logs, facility surveillance records where available, and the physical and clinical timeline of the fall and the patient's subsequent status. The goal of the comparison is to identify inconsistencies between the challenged record entries and the independent evidence of what actually happened. Under Michigan law, specifically the Public Health Code, codified at Michigan Compiled Laws, Section 750.492a, it is a felony for a healthcare provider to intentionally place misleading or inaccurate information in a medical chart or record. The law also criminalizes the alteration or destruction of medical records. The felony classification reflects the legislative judgment that the integrity of the medical record is not merely an administrative concern, but a direct patient safety issue. Per the Michigan Attorney General's press release of May 18, 2023, Nash was charged on May 17, 2023, in the 23rd District Court in Taylor, with 2 counts of placing false information intentionally on a medical chart as a healthcare provider. Both counts are 4-year felonies. Attorney General Dana Nessel stated in that release that falsifying medical records is often intended to conceal patient neglect, and that such conduct misleads subsequent caregivers as well as oversight officials, with potentially serious consequences for patients. Nash was arraigned before Judge Joseph D. Slavin and released on a personal recognizance bond of $1,500. A probable cause conference was scheduled for May 31, 2023. The public record stops at that stage. No plea, trial verdict, dismissal, or sentencing outcome was identified in the sources reviewed for this production. As with the Bratcher case, the absence of subsequent public reporting reflects the profile of the case at the district court level rather than any known outcome. The charges are allegations. Nash is presumed innocent unless and until proven guilty. The significance of this case lies in what it says about the role of the medical record itself as a safety instrument. A neurological assessment following a fall is not a formality. It is a clinical alert mechanism. If a patient's neurological status is changing, if there are signs of a developing intracranial injury, for example, the documentation of that change is what notifies the next caregiver, the covering physician, the on-call nurse, and anyone who subsequently reviews the chart that an intervention may be needed. If that document is falsified, if the record reflects monitoring that did not occur, the alert mechanism fails entirely. The next caregiver proceeds on the assumption that the patient was assessed and was stable. Whatever the underlying reason for the falsification, whether to conceal that the monitoring was not done, whether to avoid regulatory findings, or for some other purpose, the effect is the same. The next layer of the safety system receives false information. Modern electronic health record systems address this vulnerability specifically. They generate time-stamped audit trails, records of who accessed a chart, when, and what entries were made or changed, that make after-the-fact alterations significantly more detectable than it was in the paper record era. The Nash prosecution is, in that sense, a case that the contemporary healthcare record infrastructure is better equipped to detect than the systems available at the time of the Alpine Manor case 3 decades earlier. Case 8. Antonio Cerrone. A resident of a nursing home in Madison Heights, Michigan, fell, struck his head, and later died from the injuries sustained in that fall. According to the Michigan Attorney General's office, The employee responsible for the resident's care on the day of the fall was working as a nurse without a current license. His credential had lapsed more than a decade earlier. The state further alleged that before the fall, the resident had been given a controlled sedative without proper authorization, and that after the fall, the care that should have been documented as having occurred was falsified in the records to show that monitoring took place when it did not. Antonio Cerron was 55 years old at the time of his arraignment in March 2025. He was a resident of Warren, Michigan, and was employed at Mission Point of Madison Heights, a nursing home located in Oakland County. According to records from the Michigan Department of Licensing and Regulatory Affairs cited in news coverage of the case, Cerron's nursing license had lapsed in 2010. The events charged in this case occurred in December 2023, more than 13 years after that lapse. The events in question occurred on December 13, 2023. A disabled resident of the facility fell and struck his head on the floor. According to the Michigan Attorney General's charging documents, the allegation has two components. First, that before the fall, Cerron administered a controlled sedative medication to the resident without the authorization required to do so, authorization that would have required a valid physician's order and, under ordinary circumstances, would have been made by a licensed clinician. Second, that after the fall and the resident's head injury, Cerron created documentation of post-fall monitoring care that was not actually provided. The resident later died of the injuries sustained in the fall. The investigation was initiated by the Madison Heights Police Department, which responded to the incident and conducted a preliminary inquiry. The matter was then referred to the Michigan Attorney General's Healthcare Fraud Division, which assumed primary investigative responsibility. The division drew on the local police investigation, on the facility's medication authorization records to determine whether the sedative had been properly ordered and dispensed, and on the post-fall care documentation to identify the inconsistencies between the recorded entries and the independent evidence of what occurred. The licensing record review, confirming the lapse status of Cerron's credential through the Department of Licensing and Regulatory Affairs records, established the factual basis for the unauthorized practice count. Cerron was arraigned on March 12, 2025, in the 43rd District Court in Madison Heights. Before Magistrate Michael G. Mitchell, he was charged with one count of placing misleading or inaccurate information in medical records or charts, the same 4-year felony provision applied in the Nash case, and one count of unauthorized practice of a health profession, also a felony. Attorney General Nessel stated that falsifying records or administering medication without proper authorization increases serious harm to patients, and that her office remained committed to holding healthcare providers who engage in such conduct accountable. A probable cause conference was set for March 19, 2025. A preliminary examination was scheduled for April 2, 2025. As of the date of this production, no reported bindover, plea, conviction, or sentence has been located in the public record. The case appears to remain pending in the district court phase. The charges are allegations. Cerron is presumed innocent unless and until proven guilty. Even at the charging stage, the Cerron case sits at the convergence of 3 separate failures, each independently the subject of enforcement action in this episode. The first is credential status, the requirement that the person providing nursing care hold a current, active license. The second is medication authorization, the requirement that controlled substances be administered only pursuant to a valid physician order and only by a person authorized to do so. The third is records integrity, the requirement that clinical documentation accurately reflect what care was or was not provided. The state's theory is that all 3 of those requirements were violated in connection with a single adverse patient event that resulted in a resident's death. The credential element in particular connects this case directly to Case 9, which follows. The Cerron case involves an individual who held a real license that lapsed. Case 9 involves an individual who never held a license at all. Case 9. Leticia Galarzo. A woman who had no nursing training and no nursing license was hired as a registered nurse at a Michigan care facility by using a forged nursing license, a forged diploma, and the stolen identity of a real, licensed nurse. She was hired through an online employment platform. She was promoted to unit manager. She supervised other healthcare workers. She was ultimately demoted, sought another position at a different employer, was discovered, and was reported to federal authorities. She pleaded guilty, then fled the jurisdiction while awaiting sentencing, obtained additional nursing and medical employment in 2 other states using false credentials, was apprehended in California, returned to Michigan, and was sentenced to 75 months in federal prison, the 3rd time she had been convicted of falsely representing herself as a nurse. Leticia Galarzo was 51 years old at the time of her most recent sentencing, which took place on January 26, 2026. She was formerly a resident of Wayland, Michigan. Her documented history with this category of offense began a decade before the events in Michigan. Per the Department of Justice, she had been previously convicted of falsely representing herself as a nurse in Kent County, Michigan, in 2016, and in a federal prosecution in Texas in 2017. The conviction in Michigan's Western District was therefore her 3rd conviction of the same type. From August 2022 through May 2023, Galarzo worked as a registered nurse at a nursing home in the Western District of Michigan. She had obtained the position through an online employment platform while presenting herself under the identity of a real registered nurse who was licensed to practice in Michigan. To support that false identity, she had created and presented a fraudulent nursing license, a fraudulent diploma, and fraudulent identification documents. The real nurse, whose identity she stole, had no connection to the facility and had not authorized the use of her credentials. While employed at the facility, Galarzo applied for and was granted a promotion to unit manager, a supervisory role in which she exercised authority over certified nursing assistants and other staff, assigned work, and was responsible for overseeing the care environment on her unit. She held that position without any nursing training, any nursing credential, or any legitimate basis for the clinical judgments and oversight responsibilities the role carried. Galarzo's employment came to an end when her performance as a unit manager deteriorated and the facility demoted her from the supervisory role. She then began applying for new nursing positions at other facilities. One prospective employer conducted a more thorough credential verification than the facility that had originally hired her. That verification, checking the nursing license directly against the issuing board's records rather than relying solely on documents the applicant provided, exposed the deception. The prospective employer reported Galarzo to the authorities. The case was investigated by the Federal Bureau of Investigation's Grand Rapids Resident Agency and the Michigan State Police. The investigation was a document and identity case. Agents traced the stolen identity from the real licensed nurse to Galarzo's application and employment records, authenticated the fraudulent credentials by comparing them against the legitimate records of the issuing institutions, and reconstructed the employment timeline across facilities and, as the investigation progressed, across states. Galarzo was charged in the Western District of Michigan on September 26, 2023, with fraud and aggravated identity theft. She pleaded guilty in October 2023. What followed the guilty plea added a significant chapter to the case. Galarzo failed to appear for her scheduled sentencing. She had fled the jurisdiction. In the period after her plea and before she was apprehended, she again obtained employment by falsely presenting herself as a registered nurse in Illinois and as a physician assistant in California. She was located near Los Angeles and returned to Michigan to face sentencing. Judge Paul Maloney of the United States District Court for the Western District of Michigan sentenced Galarzo on January 26, 2026. The court imposed a sentence of 75 months in federal prison. United States Attorney Timothy Verhey, in his statement following sentencing, described the conduct as the result of a pattern repeated across multiple states and multiple years, noted that the investigation had not identified any patient who had been physically harmed by Galarzo's conduct at the Michigan facility, but stated that the absence of documented physical harm was a circumstance that had nothing to do with anything Galarzo had done to prevent it. He concluded that the sentence was appropriate given the pattern. An FBI official stated that the sentence conveyed that falsifying credentials, falsifying medical records, and stealing identities would carry serious consequences. The Galarzo case is a credential verification case in its simplest form. She was hired at the Michigan facility on the basis of documents she had created herself, using an identity she had stolen. The facility that hired her did not verify the license directly with the state licensing board. The facility that subsequently discovered the fraud did verify it directly. The difference between those two outcomes is a single verification step: primary source credential confirmation, checking the license against the board's public records rather than accepting the applicant's own documents as proof. The cross-jurisdictional dimension of this case also highlights a structural gap in how healthcare workforce records are shared. Galarzo's prior convictions, in Michigan in 2016 and in Texas in 2017, did not prevent her from obtaining employment at a Michigan nursing home using forged documents in 2022. The question of how prior criminal history related to healthcare credential fraud is shared across state licensing boards, background check systems, and employment screening platforms is one that the Galarzo case makes concrete and visible. Case 10. Wilfredo Figueroa Barrios. Multiple patients at the emergency department of Sinai Grace Hospital in Detroit filed reports of alleged sexual assault by a registered nurse working in that department. By the time charges were filed in August 2025, the named complainants numbered 8, and the count total exceeded 20. As of the date of this production, the case is pre-trial, no conviction has been entered, and all charges are allegations. The defendant is presumed innocent unless and until proven guilty. We will document this case as the record permits, and we will be precise about the distinction between what has been charged and what has been proven. Wilfredo Figueroa Barrios was 47 years old at the time the charges became public. He is a resident of Wayne, Michigan, and had held a registered nursing license since 2012. He was employed in the emergency department at Sinai Grace Hospital, which is part of the Detroit Medical Center system. Emergency departments treat patients who present with a wide range of acute conditions, injury, illness, intoxication, and medical crisis, and that patient population is frequently in a state of reduced capacity to respond to or report inappropriate conduct, a factor that the Wayne County Prosecutor's Office cited directly when discussing the charged conduct. The allegations span a period from December 2024 through August 2025 and involve patients seen at Sinai Grace, as well as one alleged incident at a separate location in Detroit in May 2025. Among the complainants identified in charging documents are a 22-year-old woman who was at the hospital in December 2024, a 35-year-old woman who was at the hospital in July 2025, and additional patients who were present in August 2025. A 41-year-old woman alleged an incident at a Detroit location in May 2025. The charges also extend to several additional complainants whose details have not been fully reported in the public record. The first public disclosure of the case came in August 2025, when a patient reported an alleged assault inside the emergency department. The Wayne County Prosecutor's Office filed initial charges on August 27, 2025. As the case attracted public attention, additional individuals came forward as complainants, and prosecutors filed further charges in subsequent proceedings. Sinai Grace Hospital stated, following the filing of charges, that it had contacted law enforcement upon becoming aware of the allegations, had suspended Figueroa Barrios immediately, had ultimately terminated his employment, and was cooperating fully with the investigation. The investigation was led by the Detroit Police Department in coordination with the Wayne County Prosecutor's Office. The Livonia Police Department was involved in connection with an earlier matter. Investigative methods reported in connection with the case included the issuance of preservation demands to the hospital and its parent company for relevant records, closed-circuit television footage covering the emergency department areas, access control and badge reader logs showing staff movements within the facility, staffing rosters identifying who was assigned to specific patients on specific dates, and any prior complaint files maintained by the facility. Prosecutors also charged some counts under a Michigan statute addressing sexual contact misrepresented to a patient as part of a legitimate medical examination or treatment, a statute that reflects the legislature's recognition that the clinical examination context can be exploited to commit offenses that the standard criminal sexual conduct statutes do not fully capture. Figueroa Barrios was charged across multiple case filings with counts of criminal sexual conduct in the 3rd degree and criminal sexual conduct in the 4th degree, as well as counts under the medical misrepresentation statute. The total charges across all case filings relate to 8 named complainants and exceed 20 counts in aggregate. He was taken into custody in October 2025 after being unable to post bond. Bond, in the subsequent case filings, was set at $500,000 per case, with a GPS monitoring condition attached. In late October 2025, following preliminary examination proceedings in Detroit's 36th District Court, Figueroa Barrios was ordered to stand trial on the charges relating to two of the complainants. In subsequent preliminary examinations conducted in early 2026, he was ordered to stand trial on charges relating to four additional complainants. At one of the preliminary examinations, a complainant testified regarding the circumstances of the alleged incident. Defense counsel cross-examined on questions of recollection. Defense counsel has challenged the reliability of complainant accounts and has raised questions about the circumstances under which some of the complainants came forward. As of this production date, the cases remain in the pre-trial phase. No trial has been conducted. No verdict has been entered on any count. No conviction exists. The charges are allegations, and Figueroa Barrios is presumed innocent unless and until a court finds otherwise. The civil litigation dimension of this case is separate from the criminal proceedings and is governed by a different standard of proof. Figueroa Barrios and Sinai Grace Hospital, as well as the Detroit Medical Center system, have been named as defendants in multiple civil lawsuits filed on behalf of complainants. Civil cases require proof by a preponderance of the evidence, a substantially lower threshold than the beyond reasonable doubt standard that governs criminal proceedings. The existence of civil litigation does not constitute a finding of guilt and does not substitute for the criminal adjudication that remains pending. The policy dimension of this case is significant and is not contingent on the outcome of the criminal proceedings. Reporting on the case established that in 2021, the Livonia Police Department had requested criminal charges in connection with a prior 2020 incident involving Figueroa Barrios, and that those charges had been declined by the prosecutor at that time for insufficient evidence. Reporting also established that under Michigan law as it existed at the time this case became public, law enforcement agencies were not required to report criminal investigations of licensed healthcare professionals to the state licensing board. That gap meant that investigations of this kind could proceed, or fail to proceed, without the licensing board that regulates the subject's clinical practice being informed. That disclosure prompted a public response from Michigan lawmakers. Multiple legislators stated that the gap in the reporting requirement, the absence of a mandatory notification from police to licensing authorities when a licensed health professional becomes the subject of a criminal investigation, was a structural vulnerability worth reviewing for legislative remediation. A study published in the Journal of Medical Regulation by researchers at Western Michigan University, cited in coverage of this case, found that between 2011 and 2023, complaints of sexual misconduct against licensed health professionals in Michigan increased substantially, while the number of formal sanctions issued by the state licensing authority declined slightly over the same period. The relationship between those two trends, and what it might indicate about how complaints are investigated, referred, and acted upon within the licensing system, is not established by the study alone and remains a subject of active policy discussion. Wayne County Prosecutor Kim Worthy, in public statements made in connection with the charges, stated that any medical setting should represent a safe space for patients seeking care, and that the charged conduct represented a fundamental breach of patient trust. Those statements reflect the prosecutorial framing that is consistent across every case in this episode, the recognition that the harm in cases of this kind is not only the harm to the individual patient, but the harm to the broader trust relationship on which the entire system of healthcare delivery depends.